All right, welcome everyone. Tonight we have the estate planning, revocable living trust, a whole bunch of free advice from Davis. Not tax. He is my counterpart here that I like to call my brother, and he does all things real estate, business, anything you name it from a legal perspective, bail you out of jail, which he actually does. If you're down in SoCal, he's located in Brea, California. So if you're down in that area and need some help, but he also works with a whole bunch of my clients in NorCal also. So he's California based. So yeah, anything related for legal, he'll get you out of trouble here. So tonight he'll be talking about how to protect your assets through a living trust. Also a good reminder for him to do my own that he needs to do for me. And yeah, we'll let it rip, Davis.
Thanks for that great introduction. But one thing I do have to correct you is, unfortunately, I can't solve all your legal problems, but most likely than not, if you are in jail, I can refer you over to a criminal defense attorney. But yes, my name is Davis Yu. I'm an attorney here in Southern California. I primarily focus on business and real estate, but after working with a bunch of real estate investors for the last couple of years, we've started an estate planning department, which is led by a couple other attorneys at the firm. But I'm here today to talk to you guys about estate planning, more specifically about revocable living trusts, because that's primarily the most common one that's used. And I think that for the majority of people that are joining in today, that's probably going to be the one that you're going to start off with. So estate planning, revocable living trust. So of course I have to give you guys the disclaimer that by joining in today and receiving this information from this presentation, it doesn't constitute or create any type of attorney and client relationship between yourself or myself or yourself and my firm. This presentation and any comments or information that's provided here in this presentation are for educational purposes only, and nothing should be considered legal, accounting, or tax advice. Unless Tony Hong decides to give you tax advice, then that's full liability on him. That's perfectly fine by me. So of course, like Annie mentioned earlier, everyone's situation is different. So you want to consult with your own attorney, accountant, or tax professional for any specific questions that you might have. So just briefly, the agenda for today is going to be just a general explanation about what estate planning is, probate, which is what you're going to face if you don't have a proper estate planning structure formed, some trusts, wills, and then some other instruments such as power of attorneys for financial and healthcare that you most likely will experience or have to create once you have an estate planning living trust package. And then lastly, we're going to have a question and answer session. I think that from my experiences giving these type of presentation, I think most of the value comes out of question and answer. So I'm going to try to go through my slideshow as fast as possible so that we can, leave a bunch of time available for you guys to ask questions. And then, of course, since this is being recorded, as I'm going to be going through the slides a little bit fast, there are going to be some materials that are dense, but just feel free to pause it and review it because I won't be going through each line item just for the sake of time. So just to start off, some simple statistics. 67% of Americans don't have any estate plan in place at the moment. For various reasons, such as they don't have a chance to get around to it. Nobody wants to think about their own death, right? Unless they have a personal experience where they had to go through probate. Some people think that they don't have enough assets to pass to their heirs. Some people think it's too costly. They think paying, anywhere from $2,000 to $5,000 or more for more complicated trusts, that's expensive compared to potentially losing out on maybe 6-7 figures if you don't have a plan in place. Some people say they don't know how to get a will or a trust. But recently after the pandemic, there's been a lot more people that are more interested in estate planning, of course, at least in regards to at least creating a will, which is more basic than a trust, but it's better than nothing. So 33% of adults actually under 35 stated that they've created a will because they were concerned of what might happen. And just a quick fun fact, or not fun, but interesting fact. So Prince, he died in 2016, at the age of 57, had an estate of maybe 150 million, no estate plan whatsoever, no spouses, no children. So when he went through probate, 45 individuals said that they're his heirs. And then after 6 years of trying to sort it all out and figure it out, they split his estate among 6 half siblings. And so, but ultimately what I'm trying to say is if you don't have an estate plan, you're going to pay a ton in attorney fees. You're going to pay a ton in other costs, such as the ones that I've listed here for you guys to look at. 32 million in estate taxes, which ultimately you can't really avoid unless you go into the realm of, creating potentially like irrevocable trust or managing it and just distributing it slowly through like gifting. And then 6.4 million in penalties. So just saying, before you become like Prince and have a net worth of maybe 9 figures, it might be worth looking into getting an estate plan. So what is estate planning? So estate planning is basically just the process of anticipating and arranging for the disposal of your assets and the distributions in the event of their incapacity or death. So this includes designation of heirs to inherit certain assets, providing instructions for healthcare and financial affairs in the situation that you might be incapacitated or disabled, and also like settling your estate taxes or any debts that you might have when you pass away so that your heirs don't have to deal with it. So who needs an estate plan? Pretty much everyone, or at least I think that most of the people here that are tuned in today that are here devoting like an hour of your time to learn about this probably has some reason why they're here today. So I think you would need an estate plan, you or your loved ones. Like I said, some people think that they don't have enough money. Some people think that, hey, like I'm going to be dead, so I really don't care. But you also have to think about the people that are your loved ones around you. And if you want to specifically set up your assets to be distributed in a specific way, and then not in the control of the state, then it's vital to have an estate plan. Oh, but of course there might be an outlier. If maybe you have like millions of dollars in debt and you have no assets, then I think I can safely say that you probably do not need an estate plan. Okay, so basic estate planning documents that you probably have seen or will encounter are like a will, trust, power of attorney, finances, or they're generally called general power of attorney or durable power of attorneys. And then there's also a power of attorney for healthcare, which you probably also heard of advanced medical directives or healthcare directives. So why do we have these type of estate planning documents or an estate plan in place? Ultimately, it's so that we can avoid probate. What is probate? So probate is a court-supervised process where they are going to appoint a personal representative that's going to administer your estate and distribute your assets based upon what they think that how they think that you intended to distribute your assets. Or if you did not do that, it's going to be based upon what the state generally provides for you, which is called intestate succession, which we're going to talk about a little bit later on. So this process is also going to collect and manage assets and pay off debts and taxes. For instance, they're going to require you to put a notice out to like publications out to all creditors. That's like your mortgages, lenders, student loan providers, your utility providers, pretty much everyone in case that they need to show up and claim their rights. And probate laws do vary from state to state. I'm specifically going to be talking about, or my presentation is primarily going to cover California. I always like to say that in California, we tend to think that, we are the best. So we often have the strictest rules. So most of the times, if California has it a specific way, it's probably going to be similar to the ones in yours. But of course, you want to talk to your CPA or attorney, estate planning attorney in your respective state where your property is held or your assets. When is probate necessary? It's necessary if you don't have an estate plan prior to death. And if you did not list certain assets, such as, brokerage accounts, checking and savings accounts, there is an option where you could put payable on death. But if you don't include that, that will all have to go through probate for it to get distributed. So some of the disadvantages of probate, or why we're here today to discuss why we want to set up an estate plan to avoid probate, is that it's simply costly, right? The court and filing fees, the cost of publishing notices to the creditors, costs associated with having your executor or other people pretty much administer this for anywhere from months to potentially like more than 2 years. It's time consuming. Like I just stated, it can take up to 2 years or more, especially depending on the complexity of your assets. And also they're going to be searching for documents which may not even be existent. So it might be things that you think that you have to look for, and you're going to have to go through all these different documents, all these files, cabinets, blah, 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 and find that there's nothing to be found, which is only going to complicate the process even more. Another disadvantage is the lack of privacy. Now, probate proceedings are actually taking place in open court, and the public will be able to access pretty much the list of assets that are going to be discussed. Like the financial records are going to be public record, and it also opens up the opportunity for relatives and acquaintances, maybe like second cousins, third cousins, people that you've never even met in your life, to potentially contest and claim that they have some sort of right to the inheritance of the individual who passed away, which is because you have to publicate it. And also another important thing for a lot of people is it's just cumbersome and stressful, right? You're grieving, you're going through the recovery stages of thinking about like your loved one and cherishing those times that you had. But at the same time, you're going to be having to show up to court. You're going to have to go through all this paperwork. The last thing you really want to think about is like we're constant reminders of your loved one's death and trying to figure that out, instead of going through the process of recovering. And just to be a little bit just more specific here, cost of probate. So generally when there's probate, you are going to have to either have a personal representative, or most oftentimes people use statutory attorneys, and these are the statutory attorney fees that they're going to charge you. And this is going to be based off the valuation of your assets. So it's just automatically going to be 4% on the first 100K, 3% on the next, and 2%. And then of course, here it is. So you can do the math on your own. Now, of course, if it exceeds 25 million, then they're going to determine a reasonable compensation amount, whether usually it's pro rata, so they might do like 0.2 or 0.25. Point is, you're going to spend a lot of money on attorney fees. I know a lot of you guys probably have discussed with your attorneys or have sought out to see, hey, how much is it going to cost to do a living trust package? And then they said like 3,000 or 5,000. And you said, what, that much money? But it's well worth it versus having to pay all this. So how is probate avoided? So one option is creating a trust. And for trust, there's different types of trust. There's a revocable living trust, there's an irrevocable trust, and the testamentary trust. Today we're going to cover the revocable living trust, and I am going to talk a little bit about irrevocable trust, but primarily focusing on revocable living trusts. So the basic terminology for trusts that you will encounter are the settlor or grantor, who is pretty much the creator of the trust. That's going to be you. The trustee is an individual who legally controls and manages the trust assets, and they're going to distribute the settlor's assets to the designated beneficiaries depending on how you want to do it. So they have to be at least 18 years old, and most of the times you will be your own trustee until you pass away or until you become incapacitated, or however you want to set up your trust. So it's usually going to be a trustee and then secondary trustee or successor trustee. You can also have a bank or a separate trust company or an attorney serve as your trustee for those people that don't trust anybody in their families. But unfortunately, that's going to come up at a cost, and they do get pricey to administer the trust. And then the beneficiaries are the individuals and or entities who will receive the benefit of the property and assets from a trust. So when you start off by creating a living trust, it's going to be yourself serving as the settlor, the trustee, and beneficiary, unless you designate the trustee to be someone else. And then after you pass away, it's going to go to whoever you set up to be your trustee and beneficiaries. So the revocable living trust is the most common form of living trust arrangement. Of course, the settlor can, like I said, the settlor can be the trustee until their death or incapacity. And in this lifetime, the settlor can modify, they can revoke, and they can also terminate the trust instrument while they're alive. So you can also amend it, can change the beneficiaries. For instance, if you decided, hey, my child is not so nice anymore, or the person that I wanted to leave this to is now being mean to me. So you have the option to go and change it. You can add or remove assets. You just have to change title and amend your trust. And you can designate a different trustee in case someone you thought was trustworthy and was the right person decided to do something crazy and change your lifestyle. You can also modify the terms and provisions within the trust to the way you want it. But however, when you do die or when you do pass away, the revocable living trust is going to become irrevocable. Now, there are certain ways where you can include languages within the trust that state that the trustee has the ability to change with the consent of all beneficiaries the way the trust is to be dictated, but technically the living revocable trust, it becomes irrevocable. So trust assets. So one of the most important things is everyone gets all excited or takes the step to pay a good chunk of money to get a living trust created for themselves. But a lot of times they forget to fund the trust. Now, a lot of law firms, they forget to inform their clients. Sometimes the clients just ignore these instructions, but this is one of the most vital components of actually having a living trust be operating the way it should be. So once the trust is actually executed, you have to fund the trust. So types of different assets that can fund a trust include your real estate, right? Residential, commercial, land, etc. Your checking and savings accounts, your safe deposit boxes, stocks and bonds, brokerage accounts, money market accounts, the list goes on, right? However, you don't have to include all of them. There are certain things such as annuities where it's actually detrimental to put it into a trust because, once you want to put it into a trust, the funds are considered to be withdrawn, and then that has tax implications on its own. A lot of these accounts, like brokerage accounts, checking and saving accounts, nowadays they have an option where you can fill out a form where you can designate your beneficiaries with the bank or mortgage or the brokerage company where you designate someone to be the beneficiary and by filling out the payable on death. So once you do that, once you pass away, it's easier for them. They can pretty much bring a death certificate and the account will be transferred over to you versus having it into a trust. Because once things are put into a trust, it has to be under the trust and it has to be funded by the trust. Meaning, for instance, if you put a checking and saving account into a trust, the owner of the checking and saving account should be the name of the trust. So sometimes what you don't want to do is you don't want to include certain accounts that you use on a day-to-day basis because that's going to be hard to change and it's going to complicate things. And commonly for real estate investors that are doing quick flips, you don't want to put those type of property or those investments into a living trust because you're going to have to end up amending and changing it anyways. So it's more so for like long-term investment properties. Yeah, so the title of assets that actually have the ability to, for the title to be changed, you do have to change the title into the name of the trust. And one thing about name of trusts is, oftentimes you do have the discretion to decide how you want to name it, whether it's, pretty much, actually, I'll just cover it in the next one. But the name of the trust you could change. You can make it, for instance, Davis Hughes Living Trust 2012. I can make it something like Sarah Real Estate's Living Trust, blah, blah, blah. A lot of times people like to keep it a little bit discreet or they want to keep it anonymous, so they would change the names. So some advantages of having a trust. So essentially, you can maintain control over who gets what from your estate. You can protect the surviving spouses and children. What I mean by that is you can designate how you want money to be distributed to your kids in a specific way. Ultimately, one of the most important things I think is to avoid the probate process and related costs and delays. Tax savings, you can minimize exposure to the estate and income taxes. Privacy, because like I said, you have the ability to name the trust however you want to name it. So if you name a trust, hey there, how you doing, living trust, then when people do record searches, they can't really see like who owns the trust. Because we all know that we have databases now where realtors can just put your name and every single property that you own will show up. And sometimes some people don't like that. Of course, even though you have a living trust, there are going to be tax implications. So state taxes vary. It's different I'm going to talk about California. So of course, please consult with your own tax advisor. So there's income taxes, property taxes, federal estate taxes. So briefly, income taxes, typically it's going to be considered like a grantor trust, meaning similar to like an S corp, it's going to pass through you. So if you're going to individually as the individual or the trustor, you're going to be paying taxes on your individual tax return, even if the trust generates income. And that's because technically with the IRS, it's going to be your social security number that they're going to be dealing with. So it's not going to be the trust. However, if you pass away or when you die, the trustee is going to have to file a tax return and get an EIN for or the tax ID for the trust. And the trust is going to have to start reporting the taxes. So property taxes, typically property that changes ownership is going to be subject to reassessment. Real property that's transferred into most trust, however, does not trigger a reassessment for property tax purposes. There are protections on the federal level. It's Garnt St. Germain, meaning that if you dare, and you can look deeper into it, you can just search Google it, but there are certain exceptions that don't trigger a due on sale. I know a lot of times, my clients are always scared because they want to put it into a living trust, but they see that provision like accelerated clause or acceleration clause or due on sale from their lender, and they think that their loan's going to be due when they transfer title. However, there is a protection. Now, if you own it as an LLC, that's not necessary, and it's with multiple investors, and you try to put it into a trust, you probably will be subject to reassessment. But depends on the situation, depends on your tax circumstances, your assets. So of course, talk with your attorney or your tax advisor. Federal estate taxes, very difficult to try to avoid by creating a living, revocable trust. Like I said, there are some people that will set up irrevocable trusts to try to offset some of it. However, it's difficult to do, or actually quite impossible to do with just the living trust. But just know, of course, the state tax exemption is 12.9 million for individual, 25.84 for married couples, and anything above that will just be taxed at 40%, or depending on your tax bracket. So another question I always get is, can I transfer my business interest into a trust? And typically, yes, you can, like your interest in LPs, general partnerships, LLCs, or corps. Of course, you would have to designate and assign your interest in order to put in the portion of your interest or equity into the trust. First things first, you do want to review the corporate documents of your business entity, such as the operating agreement or bylaws or shareholder agreements, because there are restrictions sometimes on transfers, which of course can be amended by the shareholders or the members of the LLC. One of the pros of being able to transfer your interest into a trust is so that, depending on how you have it set up, you will be able to allow the business to continue operations. Of course, this has to align with the operating agreement or the bylaws as well. Some LLCs, some corporations just require dissolution, but if that's not the case, and you have your interest in a trust, and you probably include language that says that the business can continue, and the distributions or profits going to be just done to the trust, and it is possible. So just real quick, want to cover irrevocable trusts. So like I told you, revocable trust, you can revoke it, you can change it, you can pretty much cancel it. Irrevocable trusts, once you create it, you can't go back, but you do gain some benefits, right? Pros are settlers can lower their estate's taxable rate. You have eligibility for government programs. Now, I know a lot of situations where you get really old, you want to get Medi-Cal, but if you have a lot of assets or money, they're going to they're going to prevent you from obtaining the benefits, or once you pass away, they're going to try to claw back and get the money back. So if you set up a irrevocable trust where pretty much all your assets are not under your name anymore, then there is a way where you can have or obtain government benefits and still benefit from some of the assets that you have. In my line of work, more commonly, we set up irrevocable trusts so that your assets can be protected from lawsuits. One thing to know is by setting up a living revocable trust, it does not protect you from lawsuits. The assets under the trust will be sought after by creditors and people who want to sue you. So if you do want to protect yourself, your assets, you do need to put it into an irrevocable trust. However, you do need to be careful because let's say I just found out tomorrow that Tony's going to sue me, and intentionally I created irrevocable living trust like today. The court does have discretion to claw back, to trace and pretty much allow Tony to seek after assets within my irrevocable trust as well. So if you are in a line of work, physicians, like attorneys or high-risk businesses, you want to think about potentially putting off some assets into an irrevocable trust before it's too late or before you find out you're going to get sued. Because if you do it preventatively, then even if they sue you, those will be protected. Some cons: can't be altered, modified, revoked. Once the assets are in place, they can't be removed. Any changes require court approval, even if you want to just change the beneficiaries. And of course, the settlor, meaning yourself, you can't be named as the trustee or beneficiary. So you are pretty much telling, creating an irrevocable trust for the benefit of somebody else, and you're kind of relinquishing your rights to that asset.
Is there like any like cookie cutter time when like the bread and butter is like, all right, you should use a irrevocable trust, or is it always it depends?
It depends. You know that already.
Well, there's got to be some times, right? Is there a general rule of thumb? There's always general rule of thumb, and then there's the exception to the exception, though.
Yeah. So, are you asking me, is there a general time where you should be setting up a revocable trust?
Irrevocable, yeah. Because
irrevocable.
Yeah.
Like we always have discussions with our clients, right? It just depends on everyone's risk tolerance. So some people, a certain amount of assets is considered a lot, and they don't want to risk it. Some people think that, hey, what do I have to lose? It's only 10 million. It's only 15 million. It's 20 million. Some people that's 500,000. So it depends on the situation. But essentially, if you want to make sure that a certain asset is going to be protected from lawsuits, and then you want to talk with your estate planning attorney to set up an irrevocable trust so that you can still reap some benefit off the asset, but that to make sure that it is fully protected. But of course, like I said, you don't want to put like quick flips. You don't want to put short-term rentals. You don't want to put things that you are already thinking about selling off in an irrevocable trust.
Cool. Yeah, it just seems like it's very cemented. So like once it's in, it's stuck. So yeah.
So you can modify it. You need the court's approval though, and that takes a long time. And then most often than not, if you reap some benefits off creating the irrevocable trust, then they're going to say, hey, okay, well, you owe us this then.
Oh, nice. All right. And then let me pull up the chat here. Oh, Victor, what's up, man? My man. All right. So when purchasing a home,
maybe I can just try to wrap it up and then we can go to the questions.
Nice. All right. Sounds good.
So you can pause it. You can look at it. These are just some standard provision, or not standard, but certain provisions that we like to include in situations where that will help you create the trust that you want, like creating spendthrift clauses in case you have a beneficiary that likes to go shop at South Coast Plaza every day, or something of that nature, where you want to control how much money they spend. There are ways where you can pretty much schedule certain distributions to be provided to these beneficiaries. You can have staggering distributions by their age, meaning they get X amount at this age, X amount at that age. And if you might have people that have substance abuse and addiction problems, so that the trustee can properly administer your beneficiary, so that they aren't spending all their benefits or money that they're receiving for the wrong reasons. So how do I create a trust? So you can always hire an estate planning attorney, talk to an attorney. You can do it yourself. You can use online services and programs where you can do it yourself, or pay a way cheaper price than hiring an attorney. But of course, you're going to be getting a cookie cutter template. And then this, you can just pause it and review it, at your own leisure. I just wanted to create some, things that you should consider, or steps when you're creating a trust. And then I want to cover a will, which, like I said from the start, it's not as good as a trust in terms of estate planning or protection. However, it's better than having nothing. However, one misconception that everyone has is if you have a will, then you're going to avoid probate, but that's actually not the case. You're going to go to probate and they're going to ask to look at the will. That's generally what happens. So for everyone who thinks that if you have a will, you're going to avoid probate, that's not necessarily the case. You do have an opportunity to have a more expedited probate process, but that's if your assets are going to be under, I think it's like 165,000, but I think there's a slide on that here. So, the definition of a will is it's also known as a last will and testament. It's just a legal document that contains a person's wishes as to how their property is to be distributed after death. So, you can write it, and it just has to be written though. You can handwrite it, it can be typed. So basic terminology, testator is the creator of the will. That's going to be yourself. So that's similar to a grantor for a trust. Executor is similar to like a trustee. It's the person that's going to manage the estate of the deceased testator and distribute the finances and assets. Typically, you want to designate an executor in your will, but if you don't, then the state that you live in will have its order. And then, of course, you still need your beneficiaries in terms of which individual or entities are going to receive the benefit of the properties. Does a will have to go through probate? It depends. So if the estate is valued at 184,500 or less, then it's going to be able to go through like a small estate procedure, quicker, simpler, less expensive. However, if it's more than 184,500, then you will have to go to probate. And then when you go to probate, like I said, you're going to have the publications. All the creditors are going to come and seek what they would like, and then after that, they're going to look at your will to see how it should be distributed. And of course, this valuation, the 184,000, it changes. So you just want to make sure that you're aware of that. It was at 166,500, but it changed to 184 recently. So what happens if you die without a will? In California, the interstate succession laws are going to determine where your assets and property will go when you pass away. Generally, the order is going to be your surviving spouse, if you have one, and then your children, your parents, siblings, grandparents, and then lineal descendants of your grandparents. If you have no heirs, it's going to go to the state of California or the state, or Then you have both a trust and a will. Yes, in California, you can have a living trust together with the will as part of an estate plan. So most often you're going to see a living trust package can have a pour-over will, which is going to be in conjunction with the living trust. So in case you forget to fund your trust while you're living, if you pass away, it's going to pour over into the trust. So will versus revocable living trusts. Like I said, will is more simple. It's effective upon passing away. Executor is appointed to administer your estate. You will have to go through probate process, like I said, unless you have assets, and these assets are both cash and your equity in any property. So let's say you have like an equity of 100K in like your house, but you have like $200,000 in cash, then you will have to go through probate. Some trusts, of course, there's more upfront costs. However, it's effective immediately when the trust is executed and funded, and the trustee is appointed to manage and administer your estate. You have more control over how your assets are going to be distributed. And more importantly, and most importantly, I think, is you avoid the probate process. So one key difference between a will and a trust is a will becomes effective once you pass away, and a trust is effective when you create it. And then a couple other documents, like I said, power of attorneys for healthcare and financial. These are things you're going to be having if you talk to an estate planning attorney or just see online, where you can designate specific agents to act on your behalf for financial decisions and healthcare decisions in the case where you might be incapacitated or disabled. Yeah, so for financial power of attorneys, there's a general, limited, durable, springing. General, you give broad powers. They can manage pretty much all financial affairs. Durable, authority to manage affairs continue even after your incapacity. Limited specifies what powers and authorities the power of attorney will have. So limited power of attorneys, you pretty much designate like what they have the ability to control. General, if you do that, then they are going to be able to control anything. And similarly to healthcare directives or advanced healthcare directives, you're going to designate an individual to make healthcare decisions on your behalf in the event where you can't make decisions on your own. Such as, like, for instance, the key ones are like life support, I think I go more into detail here. So power of attorney for financials, you can appoint an agent. And these are some of the things that they will have the ability to do, such as buying and selling property, negotiating contracts, paying bills. And then for healthcare, here you can just take a look at this, I think, because I want to free up some time for question and answers. So I think one of the most important things is just to get the conversation started. So you want to speak with your trusted family members on who's going to be the right person to serve as the trustee or executor. Do you want life, and for yourself, you want to figure out if you want life-sustaining treatments, who's going to take over your business, who's going to take over yourself when you are in a state of maybe incapacity, or if you are disabled. Of course, talk to your financial advisor, accountant, and attorneys when you have these conversations, because everyone's situation is different and they can provide some insight and input before you create an estate plan for yourself. So if you do have a trust or a will, please review and make sure that these documents are accurate and drafted in the way that you want. A lot of times, you're going to get these trust documents that maybe are 20 to 30 pages, and you pretty much have no idea what they really state. Yes, you do get questionnaire from law firms as you're about to create this, where it says, hey, what do you want to happen if this happens? However, of course, attorneys are human, so they make mistakes. And the last thing you want is to think that this was drafted the way you wanted it to, but find out that it's not. So if you do have one already, take a look, devote some time to read through it, and just, of course, if there's something wrong or if plans changed, update it. Talk to your attorney or whoever created this for you. And of course, if there's any updates, or maybe there's some assets within your trust that you've already sold off or that are no longer relevant, you want to remove those. And if there are ones that you want to put in, you want to fund them as well. Wait. So let's do some questions now.
Oh man, we got a ton. So I'm just gonna be selfish here, well, along with Danny.
Okay. Well, I'm just gonna say it depends for all of them. So let's start it off, Tony.
All right. So if you have assets in a living trust and you get sued and they touch those assets,